I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit.
You could stand up, sir, unless you're disabled.
Oh, sure. Sorry, Judge. I told him to have a seat.
Aaron Flesher.
All right. And Mr. Westmoreland, your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Flesher.
All right. And Sergeant, your name?
Detective Sergeant Driscoll, Trent Police.
It looks like Judge Mullins, I believe I was absent that day, as I recall it. I don't know if you remember, Lisa, but I was absent, and Judge Mullins, my place, I think,
Yeah, you're correct.
set a $5,000 10% bond in order to not to have any contact with Adam Grote, not to enter or go near 3750 Brookshire and Trent, no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs, no firearms, no dangerous weapons, and defendant was recorded.
Right out of the gate, we're not talking about a missed court date. We're not talking about a simple bond violation. We're talking about a man who believes he broke a code, a secret so powerful, so dangerous, that it's allegedly put his life at risk for nearly 2 decades. And today, that belief is colliding headfirst with the cold structure of a criminal courtroom. On one side, you have the judge, methodical, composed, grounded in procedure. On the other, you have Mr. Flesher, unemployed, homeless, claiming intercepted phone calls, sabotaged vehicles, and a government-level conspiracy. The issue before the court? A simple failure to obtain a GPS tether. But what unfolds is anything but simple. Is this fear legitimate? Is this paranoia? Or is this a defendant spiraling under pressure? As this hearing progresses, pay close attention to the judge's tone, because you can already sense the shift from routine bond discussion to something much deeper. And by the end of this, the court won't just be addressing bond conditions, it will be addressing mental competency concerns.
24 hours of release from custody. So, hang on one second. Yeah. I'm going to talk to you about fucking cheap marijuana. I've been meaning to talk to you about that for 2 weeks. Okay, so then I got a signing on record on the, he was in Chattanooga, failed to acquire the GPS. Court found by a preponderance of the evidence that the defendant violated his bond condition by failing to acquire a GPS. I revoked the release, forfeited a bond, and ordered $50,000 cash or surety. So, what are we going to do on this one, Mr. Westmoreland? I mean, I could take, you can just argue bond, or if you want to have a bond hearing as to whether or not he failed to acquire his GPS tether as ordered by Judge Mullins, that's fine too. What is your preference here?
Your Honor, I would just ask that this matter be reset, and I will argue bond on behalf of Mr. Flesher.
Sure, go ahead.
Your Honor, I would like you to know that Mr. Flesher is currently homeless, and he is currently unemployed, so he has no means of paying for any sort of tether. He's not currently on probation or parole. I don't believe he has any prior criminal history. At least he indicated to me he did not. He has no other pending matters out of any other court. And after speaking with Mr. Flesher at length this morning, he did assure me he would be appearing at all future court dates, and he does understand the importance of doing so. I believe last time he felt that he was threatened and he could not appear. But moving forward,
Wait a minute, say that again.
Mr. Flesher indicated to me that he felt that he was in grave danger and he could not appear.
Danger by who? From who?
Your Honor, I'm not exactly sure at this time, but Mr. Flesher did assure me he will appear and he understands the importance of doing so.
Did he make any police reports?
Not to my knowledge.
I don't know if Judge Mullins ever signed the complaint. I wonder if we can send that. Can you send that over to her? Oh, wait a minute. She signed the warrant. She did sign the complaint. Why did you leave without getting a GPS tether, sir?
Now pause right here. The court isn't guessing, this isn't speculation. The record shows he was ordered to obtain a GPS tether and failed to do so. That's not a gray area. That's a direct violation of bond conditions. And when bond conditions are violated, judges take that personally, not emotionally, but institutionally. Because bond is built on trust, the judge even gives defense counsel an opportunity, argue bond, or have a hearing on the tether issue. That's procedural fairness in action. But the bigger issue is already forming beneath the surface. When someone doesn't comply with a GPS order, especially in a case involving no contact provisions, it raises concerns about flight risk, public safety, and credibility.
Danger, and that's what set this whole thing in motion.
Your life is
The
in
mail-
danger.
I have no interest in defrauding, Grow It, Adam, or
I want you to talk
anybody
about
else.
the, hang on. I
What, sir?
want you, hang on. I want you to talk about the case. You should not be talking about the case.
Okay.
I don't know why you're telling me your life was in danger. Did you tell Judge Mullins your life was in danger when she was setting the bond?
Yes, I've told everybody.
He tell you this, detective?
He did not, Judge. Me and Mr. Flesher has not had any real conversations to that effect.
You told Judge Mullins at the time of the arraignment that you felt your life was in danger? I don't want to put words in your mouth.
A tether tracks to exactly where I am.
Say that again?
The tether would track to exactly where I am. I was moving around to try to avoid. I have to give you the whole story, or you don't get the whole picture. Yes, my life is in danger, absolutely 100%, and I have documentation that proves it inside and out. That's why I'm more than happy to come to trial. I'm more than happy to speak to a judge and a real lawyer and everything else. I have no problem with that.
I'm a judge, and he's a real lawyer, and he's a real detective.
Okay.
Listen, Mr. Fleeser.
This is the turning point. Up until now, this was about bond compliance. Now it becomes about perceived danger. Notice the judge's immediate reaction. Danger by who? From who? That's not dismissive, that's probing. Because if someone is genuinely in danger, that's serious. But if there are no police reports, no documentation, no prior mention during arraignment, then the credibility starts to wobble. And here's what's fascinating, the detective confirms there were no real conversations about threats. So now the court has conflicting narratives. The defendant claims grave danger, law enforcement has no record of it. This is where judges begin evaluating not just facts, but mindset. And when a defendant starts explaining bond violations with broad, undefined threats, it sets off alarm bells in a courtroom.
You were ordered to get a GPS tether. I know not what you're talking about, sir. I do not know what you're talking about. Have you ever treated for mental illness, sir?
No, sir.
Do you work?
I haven't worked in a long time, sir.
How long?
I don't have a problem working. I'm not a bum. I have skills. I'm more than
Nobody said you
capable.
were
My
a
phone
bum. How
calls are-
long since you've worked?
Since. So you mean since I've been paid for work? Probably about April 2008, maybe.
Where do you live now?
I'm denied employment. My phone calls are intercepted.
Where do you
My
live now?
Visits to law offices are intercepted.
Listen to
Just
my
telling you,
question.
I want to be honest with you.
Well, I want you to be honest with me too. Where do you live now?
I go from hotel to hotel to hotel to outmaneuver whatever the heck it is that's coming after me. I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit. The code is basically how they get rid of people they don't care for.
The federal government you're talking about?
Correct.
Oh boy.
It's none of it's legal by any means, but it's very damning to say the least. So I kind of keep that to myself, but it doesn't allow me to survive. Like I said, I'm not choosing to have my calls intercepted. I'm not choosing to have my automobile sabotaged, my family's home sabotaged, the list goes on, and that's why I know you don't want to go into detail. But I have to be honest with you. Yes, my life is in danger. That is the whole reason.
And here it is. The tether becomes the center of the fear. He says it would track exactly where he is. That's the purpose of a GPS tether, accountability. But in his mind, it becomes vulnerability. Listen carefully. He says he was moving around to avoid whatever is coming after him. That's not just fear, that's active evasion behavior. From a judge's perspective, that sounds exactly like someone avoiding supervision, and when he insists he has documentation that proves it inside and out, yet none has been presented formally, that gap becomes critical. Courts rely on evidence, not assertions. The judge even cautions him about speaking too much, because he's potentially making admissions against his own interest.
Why I took the mail that I took.
All right, you should
Don't
not be
speak about
saying
that.
that. You should not be saying that. You should not be saying that, sir. You just should not be saying that. I'm trying to
You want
caution you. Not listen to me,
demonstration why my life is in danger.
please listen.
Go ahead.
You shouldn't be making admissions. You should not be making statements that are against your interest. I'm concerned here. I don't know what to tell you. I'm going to set $2,000 cash or surety. $2,000 cash or surety that you're going to have to post. And this time, I'm going to change the bond conditions ever so slightly. You're not to have any contact with Adam Grote. You're not to have any contact with prosecution witnesses. You're not to enter or go near 3750 Brookshire in the city of Trenton. You're not to possess firearms. You're not to possess dangerous weapons. You're not to purchase, possess, or consume alcohol or illegal drugs. You're not to be released until fitted with a GPS tether. You're not to be released until fitted with a GPS tether. So even if you post the bond, you're not going to be released until they can fit you with a GPS tether. Also, I'm going to order you to attend a psychological evaluation and treatment. You can call the probation department. So if they recommend probation's going to give you some names as to where you can go. You're to attend a psychological evaluation and treatment if recommended. So those are the bond conditions. I'm adding a couple that Judge Mullins did not have. And you have never heard anything about this at all, Sergeant?
I have not, Judge. I know there was some conversation about his money.
This is where things intensify. He's homeless, unemployed since potentially 2008, claims intercepted phone calls, sabotaged vehicles, sabotaged homes. The narrative expands rapidly. From a legal standpoint, instability raises flight risk concerns. From a human standpoint, this sounds like someone living in constant perceived threat. The judge is trying to anchor him to simple, direct questions. Where do you live? But the answers spiral into broader conspiracy. Notice the structure. When asked for a current address, he responds with evasive movement and unseen forces. That disconnect is significant. Courts evaluate credibility in real time. And when answers don't align with questions, it shapes judicial perception immediately.
Being funneled out of his bank account, but we didn't get into a conversation involving people coming after him.
All right. So, Mr. Fleezer, I'm sorry. I'm going to give you a new date. It's going to be, January the 6th, is it? Lisa?
January 6th at 10 o'clock.
January the 6th of 2026 at 10 a.m. I hope you didn't pre-try that with those guys. I told them we needed an Arabic interpreter.
His son spoke for him.
Yeah, I can't do that. It's a criminal case. I just can't do it.
I understand.
I just can't do it. I tried to tell them that. I mean, it's a criminal case. I'm supposed to get an interpreter, so I can't. I'm sorry. I just can't do it. That's the way it is, Mr. Fleezer. I'm sorry. So I want you to get a psychological evaluation and treatment. You can post you post $2,000 and you're not going to be released until fitted with a GPS tether. Okay? Do you understand, sir?
Yes, but I don't have $2,000.
I'm sorry, you should have shown up. You should have shown up. You didn't get your tether and you left the state
I was
without.
told that,
Sir,
I was told that the actual
Sir.
judge wouldn't be there.
what's that?
I was told the actual judge wouldn't be there, that somebody would be sitting in who doesn't actually normally be there. Plus, the lady that I spoke to, that was the judge, had the
Yeah.
same name as you, sir.
No, she did not have the same name as me. It was Judge Mullins. It was,
It did on the screen when I talked to her, because I was wondering why it was McNally, because that was the paperwork posted on her house.
okay, listen. You were in front of Judge Mullins. You were in front of Judge Mullins. She told you to get a GPS tether. You didn't. I'm not going to argue with you. You're going to have to post 2,000 and they'll give you a GPS tether. If you post the bond and you get the tether and you are released, I want you to get a psychological evaluation and treatment, okay? They don't need to come in here. I already told them to go down the home.
I know, Judge, you can speak English. Young.
No, Mr. Muhammad, come on. He told
Judge,
me
we all
he
set?
could just, yes.
Thank you,
He
Judge.
All right,
told
thank
me
you.
he- Told me he could.
Up to this point, the claims were vague. Now they're expansive. When someone claims interception, sabotage, government-level orchestration, without presenting structured evidence, courts begin considering competency evaluations, and here's what's telling, the judge repeatedly cautions him not to make admissions. That's not mockery. That's concern. Because defendants sometimes harm their own defense by oversharing in open court, this is a judge trying to balance two things simultaneously, enforcing bond compliance and protecting the defendant from self-incrimination. That balancing act is subtle, but crucial.